which is case law 1.
1 minute also. Is also rejoined.
Yes, for CJI binder.
Which was circulated earlier today.
And one list of authority volume 1.
List of authority volume 1 I got. Yes, we joined the submissions also.
Written submission is second last.
We joined the submissions. Volume 1, right? Yes.
Each of my lords has got that.
Yes.
Yes. Now let's, I've got about half an hour, so I'll be very pointed. So they have about 10-15 minutes left between them and us. Please see the larger issue for a minute, and then I'll read only some part of these two notes.
The rejoinder one?
Other one?
Which one you want us to take first?
No, Lordship may have all three open. I'm not going to follow this sequence, because I'll just go between rejoinder note, my first note, and CL1.
Yes.
These three things are 95-98% of my solutions. I'll take a different sequence to make it shorter. Right, Willis? Now, my opening point is, Willis, that Willis, if your lordships were to go by this, what I call the absolutist theory of signatory or Willis party in that sense, then your lordship must throw out completely the doctrine. If not, then the best your lordships can and perhaps should do is to consider where the existing law needs trimming or safeguarding. That's point number 2. Trimming is a more appropriate word. Why, Willis, I say trimming? Because according to me, my lords has already fleshed out 10, 12, 15 legal principles, which ring fence that doctrine already from abuse. Now, certainly to the extent my learned friends on the opposite side tell your lordships that this doctrine ring-fenced by these 15 principles needs further tweaking in this particular sentence, I am with them. I have no problem. But the problem with this case is they have not told your lordships that. They are suggesting again and again, by creating an apprehension without telling your lordships which of those safeguards needs tweaking, so as to actually reduce the doctrine to vanishing point. So, without telling your lordships, because they know they can't say that, they can't tell your lordships normally, please throw out the group companies doctrine. Actually, that is a logical thing to say on their side. Realizing that that may either be unpalatable or discretion is the better part of valor, they say, no, keep the doctrine, but put so many unknown conditions which reduces to vanishing point, which is another way of saying throw it out. One of those points is, must be positive or negative wrongdoing only. Only an example, I'll be reading in a minute. Take, for example, the repercussions of that point, Willis. That means that absent even piercing the veil is not merely based on wrongdoing. It's a misrepresentation to your lordships to suggest that piercing the veil is based solely on wrongdoing. My lord pierces the veil in a wider set of contexts. But Willis, that would mean that your lordship will either equate the group doctrine only with piercing the veil. It's not the way it is put by the other side. It amounts to that. So, Willis, please ask them which particular safeguard, and the lordship is to be reminded of those 15 safeguards. Please ask them which of these safeguards is not enough, in what manner. That's a constructive exercise. I would join them in that. But because absent that, please don't let it be reduced to vanishing point by a circumvention or a camouflage. That the doctrine is okay, but in some unstated manner, don't apply it to a non-signatory or to a non-party, which means there is no doctrine at all. Now, with that backdrop, please turn to Malas 3 portions in a different sequence. First, turn to my rejoinder note, the last page. I'm following a little different sequence, Malas, it will be quicker. But remember these 3 points, Malas, which I said in the opening. With that backdrop, kindly turn to the last page of my rejoinder submission.
Para?
The very last page, Malas, it's a kind of an appendix.
Seventh.
It's not a para. Does it have the title, Malas, test for recognition? Now, Malas, what I've done here is I've done the reverse, and I think you'll actually find it useful. I have, Malas, put the test or the concept and then the case law under it. It's already there, but I've done the reverse. Now, Malas, just give me a few minutes. I'll not read a single case on this page. One test is intention of parties, commonality of interest necessary to bind non-signatories. First of all, Malas, as my learned friend Miss Arora also said, I said in the opening, this non-signatory is, Malas, a complete red herring phrase. This phrase non-signatory actually has no place in this jurisprudence. I'll tell you why. Because if you're a signatory, the doctrine doesn't arise. It doesn't arise. Then you must have an all or nothing. The moment you're not a signatory, the doctrine doesn't arise. Full stop. Your Lordship throws out whatever your Lordship wants to throw out. So the whole doctrine is, yes, a non-signatory can be there to what extent?
Express party, implied party.
Implied party. Now, Malas, so non-signatory, of course, we are using in the jurisprudence, so it's okay. It can go along, but that's the concept. Now come to this. Intention of parties, commonality of interest necessary to bind non-signatories. Now, Malas, just see, these are chapter and verse specific paras where my Lords has in 3 judges, 5 judges, or 2 judges laid it down. I'm saving time to specific paras pinpointed. And I'm grateful to my learned friend, Malas, Mr. Himanshu Mehta, Malas, for having done that exercise under my supervision, but Malas, it's useful to have it called out. And I've got CL1, which is your Lordship's volume 1, otherwise sometimes CL2. Now, Malas, so many times your Lordship has done it, the question your Lordship should ask is, what is the imperative necessity of throwing out this whole page? Because, Malas, if your Lordship really were to apply the true test, then your Lordship should throw out this page. Reverse this page, overrule this page. Now see the next test. Alter ego piercing of corporate veil may be required. My Lord has given reasons. My Lord has had in 2, 3 and 5 years and given reasons. Now, unless something compellingly wrong is shown there, all this should be overruled. Then, Malas, engaged in negotiation of performance of the commercial contract. Well, actually what happens is, this answers both the shielding point and the wrongdoing point. Well, your Lordship does look for the intent. Let me give a nuanced answer to the point here. Of course, your Lordship goes by intent. But intent is both a subjective and an objective test. It's not a subjective test where I tell your Lordships, I know I'm fully involved in this contract, but I will create a structure whereby, despite my full involvement, I will say my intent is to shield myself from arbitration.
As one of the cases said,
That your Lordship's objective test kicks in. Your Lordship is the judge there.
subject, as one of the cases said, that you deduce the subjective intent of the parties from objective facts.
That's my next sentence. Therefore, the subjective intent test alone is constitutive of great injustice, and then your Lordship must overrule the doctrine. What your Lordship has never done is no or yes are black and white. My Lordship has operated in the zone of grey. Otherwise, why does your Lordship have these 15 principles? Because your Lordship knows case by case justice can't be done without these 15 principles. Otherwise, Lordship says, yes, we accept it fully or we don't accept it at all. No, your Lordship says we accept it, but family-run companies through complex structure is one test. Yes, we accept it, but tight group structure with strong organization, financial links is another test. That is the right way to do it with respect, because your lordship will then be doing justice without straitjacketing it in an exhaustive manner for unknown speculative situations in the future, which your lordship can never predict. Your lordships can never predict. Does your lordship want that injustice on a logical application of the other side's case? My respectful submission is answer has to be no. Yes, if your lordships can be pointed out any major fallacy or error in this page 6 principles I have given, then your lordships can tweak it. Has anybody told your lordship specifically in what language to tweak it? With great respect, I ask that question of myself. Not really. Either it's a throw the baby out of the bathwater or say it in a generalized way without telling your lordship which principle is wrong here. And that subjective objective is very important for the Chief Justice also, Justice Narasimha. If your lordship were to give extreme and dispositive, conclusive weight to subjective intent, then really your lordship is saying every non-signatory is out. Because the intent of the non-signatory is not to be bound. Then why have a signatory, why have a doctorate at all? It is already that your lordship's objective intent kicks in and balances the subjective intent. But it has never been the absolute subjective intent. My lord applies the mind, that objectively the whole system is there. Just because he has ring-fenced or created a structure, we will not leave our adjudicatory job of injecting some objective intent to do justice. That's the real crux of the matter. So, as I leave this page, my 2 or 3 takeaways, if I may use the word, is 1, would your lordships have any compelling need shown to your lordships by the other side to overrule this page? Is question number 1. The lordship has jurisprudence, the lordship has case law, the lordship has decisions. There must be something shown why the constitutional bench. I'm not saying lordships can't do it, but really many or all of these should be overruled. And certainly, because I find the compelling need, if at all, is the opposite side, not this side. The second takeaway from this page is that, I'm sorry, my apologies. As well, and friend adds rightly that to 10 years after chloro, your lordship is celebrating the decade of chloro. So your lordship should overrule.
10 years after, but it's just a thought. I think we haven't yet come across a critical mass of contradictory views in the context of chloro control principle. It's perhaps a little too early. As you are saying, that there are another set of cases which had proved to the court that this doctrine is excessively applied or overarched or wide enough, so much so that the court should take a step back and control. We haven't yet arrived at that situation, is what you're saying.
I'm extremely grateful, and may I, with your lordship permission, adopt that phrase, critical mass. That is the critical phrase. It is possible for a constitution bench which finds a predisposition of a mass of cases this way and that way, that is either equal or heavily weighted against the chloro doctrine. It is possible your lordship reaches a critical mass sometime in the future. Otherwise, really a constitution bench is being asked to do an extraordinary thing. And again, it is left unstated by them because they know if they put it like that, lordship would find it unpalatable. So it is not put like that.
To be fair, they have not put it at that level.
That's my problem. They have not put it, actually they mean that level. Exactly what that's my submission to your lordship.
Right, you are saying that.
The consequence inevitable is that. That's the point.
But they have not brought forth, as Brother Narasimha said, the critical mass of evidence.
Let's just look at this critical mass phrase, very important phrase. Your lordship has got most of the cases actually on this chart. I mean, there will be 2 or 3 missing, but most are in this one page. The interesting thing is that the critical mass is leaning in favor of chloro. So what is the constitution bench being asked to do? It's asked to create a new status quo without showing that the existing status quo has run amok. without demonstrating in any reasonable way that the existing status quo has run amok. For example, your Lordship has some judgments. I'll not name them as the old times, etc. I mean, one I can name as I argued Balco, private with Bhatia. The Lordship has evidence that international commerce was being affected. There's a whole UN cry. But Chloro, these judgments have been controlled. They've been actually very calibrated, very careful, cautious. They've not gone overboard.
You get the point.
This is
What's
now, the second aspect is, come to my first note. Section C. Well, let's just stop for 30 seconds on section B. I formulated the two issues. We must remember the origin. These are the only two issues. In my B.1, this is the first note, the opening note. I'll not read it, Lordship knows. This really should be a Lordship's broad guiding pole star, these two issues. And none are made out in favor of the other side. Whether the acceptance, etc. of the group doctrine by several elders is not permissible within the four corners of 96 Act. That's a clear, good guideline to follow. And second is divorce about whether you should. Original and rejoinder.
Yes.
The broad guideline. Now come to section C, category C, lower down that first note itself, first note, opening note. What are those 12 or 15 principles? I'll read a sentence each. It's the same chart, but put in the point of submissions, put in the form of submissions. So first is true and genuine effectuation of the real intent of parties. But real intent where it becomes a form of avoidance, no, then the objective test comes in. Suppose the Lordship were to find in a case that the real intent actually by performance, by context, by negotiation is not to be involved. Then the Lordship will say, no, there's no group doctrine. He's not bound by arbitration. The Lordship is entitled to the existing law. What is wrong with that law? My Lord says enough tools not to punish an innocent party. Second, related entities playing a predominant role both at the negotiation stage at the inception and in the performance. Now, suppose, both these tests, this is an answer also to the subjective objective which my Lord Chief Justice formulated. Suppose your Lordship gives a finding of fact in not this case, actual case, that I am fully involved in negotiation, plus I am fully involved in performance. But because I am a foreigner, I have so designed it that I don't want to be caught in arbitration. Doesn't matter. Sorry, it doesn't matter. Your Lordship should be able to control that. Absence such a group doctrine would allow evasion and avoidance of legitimate collective responsibility. That's a consequence. I'll leave that. Hypothetical approach. I'll leave that. Now, certainly the whale doctrine, even they have conceded. That's C.5. Even they are conceding in some form or the other. But certainly I am not agreeing that it is coincide with only the whale doctrine. Rest of what we've seen, a very, very important concept is C11. This is a judicial policy and a public policy. Not that any single swallow will make a summer. No single point is enough. But the totality your Lordship will see. In a genuine case where a Lordship gets a fragmentation, why should Lordship allow it? In effect, you are using it to stop what? Legitimate arbitration. Look at your Lordship's pro-arbitration approach in a whole set of jurisprudence. In effect, C11 means you are thwarting arbitration because you are fragmenting it. In effect, no effective decree is passed. Then I've given C9, which is composite and all that. Anyway, this is just to remind my Lord that all of these principles are there. I'm not reading about them. There are about 12 or 14 of them. Well, it's a word here, and then I go back to my agenda note. C15 and C16 are more important than they are given the weight of. Claiming through or under in the law commission is not being given enough weight by the other side. If that is so, Malus, then merely saying non-signatories will not, Malus, nullify this. I've given various reasons for C15 and C16. That has not been answered, that has not been really dealt with. That, according to me, Malus, I reiterate fully. The entirety of the Law Commission, the 2(1)H argument, Section 8, I'm saving time, I'm not reading it, Malus. That is an important consideration in a particular case. Now I come, Malus, to my rejoinder note. And turn to my rejoinder note. Very quickly, Malus, I'll finish within time. First is, who is a party must be in accord and comply with principles of law of contract. That's the point. I'll not read the point, but I'll read the response. 72 of chloro in my CL1 provides for clear intent to bind signatory and non-signatory, cannot be restricted only to intention to consider peers for cooperative, alternative, tight group structure. Same point I made. Second point made is party autonomy. So was the first point I really made. If Lordship appreciates what I'm saying, I'm not really reading it. First. Second is party autonomy. Kindly come to my response. It is essential to understand the true intent by way of their conduct. It is simply the reliance solely on party autonomy would negate the doctrine. This Honorable Court in ONGC in para 40 has laid down the test. Mutual intention, relationship of a non-signatory, commonality of subject matter, composite nature, performance of contract. What's the point of ring fencing with 5 safeguards? If it is so simple, well, as party autonomy, then all this is useless. Clearly, I am a non-signatory. Clearly, I am not. What's the point of all the lordships? On the contrary, a lordship is finding a way to effectuate the doctrine while protecting. And that's the right approach. Third, privity of contract. Same answer. These are all traditional doctrines. Law will not advance if you go back to privity. Because how many categories does a lordship have where privity is not sacrosanct? Does a lordship have less categories of privity not being sacrosanct? Whereas there is a book by Michael Atiyah, which I read in my student days, The Beginning of the End of Contractual Intent. This is written almost 70 years ago. English people who are conservative found the beginning of the end of contractual intent. And a lot of us today told party autonomy and contractual intent is conclusive and dispositive. Maybe one of how the same cannot be sole based. In fact, case of non-signatory, this court has used the doctrine of piercing the cooperative. Non-signatory may be held to be bound on a consensual theory, found on agency, assignment, non-consensual basis, estoppel, altering. The courts have added additional elements, common intention, negotiation. These are of juristic principles by eminent authors and a lot of judgments which has adopted those authors. Gary Bourne, etc. have given these theories. Then there was 4. It's a repetition, really. With the para given of para 39 ONGC. Para 4 is that. Now this through or under is para 5. Through or under. Through or under relates to my first note C15 and C16. Just to cross-reference it once. My first note C15 and C16. In addition, it has been held in para 73 of chloro that a non-signatory could be subject to arbitration without their prior consent in exceptional cases. The court may lay down the parameters which permit play in the joints. The court will examine these exceptions of the custom of direct relationship of the party to the agreement, direct commonality, and agreement between the parties being a composite transaction. Then this US and Germany, I'm not spending time in para 6. We'll come to para 8. A point I've already made for us. Compelling reason, entrenched doctrine in Indian law. Compelling reason not shown to your lordships. An entrenched doctrine is para 8. Para 9 was about implied consent, a phrase which fell from your lordship, section 7. The above submissions cannot be accepted for the reasons. A, doctrine be applied in facts and such that each case cannot be a straitjacket formula. And if your lordship were to adopt this all or nothing, then there will be no grey area. Lorships can't handle individual cases in future then. But GCD is a reasonable and a natural extension of piercing the veil doctrine. Some or all already established legal tests regarding piercing would be applicable depending on individual facts. Then, you have chosen a private forum as argument number 10. Parties have a right to choose the forum and the parties to the agreement, but circumstances arise where a non-signatory company can be roped into arbitration because the court found the existence, quote unquote, from MTNL, a tight group structure with strong organizational and financial links so as to constitute a single economic unit or a single economic reality. If your lordship comes to that factual conclusion in a case, why should the tyranny of an intention doctrine defeat this? Is my question to myself. Then 11. Diwan and for Mr. Advani, but I would beseech my lords to keep one thing in mind. Your lordship already has sufficient guidelines. Naturally, your lordships can tweak it in this way, that way, little bit to make sure it's strengthened. But otherwise, there is nothing in this case in terms of either absolutist or completely. Otherwise, it would actually wreak havoc on what is now an established trend of law. That's very deep.
Dr. Singhvi, amongst the multifold talents that you have, you also have the talent of lip reading. Lip reading.
Even if I did, I would not disclose. It's a very valuable talent so long as it's kept hidden.
Because that's a talent by itself.
I can assure lordships, I don't. I don't. And I'm glad to hear the subtext of what a lordship says seems to be in my favor, but I don't know. I'm never presumptuous about adjudication.
Dr. Singhvi, you may not want to
Because you closed.
You may not want to reveal a bar secret, but I can tell you a secret which I picked up. I was sitting exactly where your junior is sitting, and where you are standing, Mr. Fali Nariman was leading me. That was the withdrawal of the prosecution of the Chief Minister power under section 321 of the CRPC.
Oh, yes.
Had come up and had been referred to a constitution bench presided over by Chief Justice Bhagwati.
Shivanandan Paswan was.
Right, Shivanandan.
I was on the opposite side.
Supreme
I
Court.
was on the opposite side.
And, that was where Justice Bharuli...
3-2. Justice Venkatramaya, 3-2.
That's right. They ultimately, the matter went 3-2 in the constitution.
That's right, 3-2.
So the judges were conversing, and I was briefing sitting by the senior Mr. Nariman. And I thought that I'll use the time, to tell him what our next line of authority was going to be. So he turns to me and says, never, never speak when the judges are speaking. So I said, sorry, Mr. Roy. Then when we left the court at 4 o'clock, he says, that's when you get to know the mind of the judges. Something which has not left me, learning lessons from the greats at the bar.
I shall pay more attention to this very wise advice.
We are now inventing how to read the minds of lawyers while sitting here.
I believe that.
Deeply obliged.
Very
Very deeply obliged.
Your lordships know what happens when we are on this side.
Yes.
Look, I'll just take about a minute and a half, 10, 15 seconds for me
I never forgot
to respond to what Ms. Arora said.
Yeah.
1 minute, Manoj, to respond. As far as the submission which Ms. Arora had made, there's just one aspect I want to point out. That while it is a section 9, the entire determination which your lordships will see at paragraph 6, 7 and 12 of the judgment was only on the group of companies doctrine. So as far as the issue is concerned, the issue is in fact the identical issue that your lordships is hearing in 501. So it shouldn't be delinked in any form. That's the only one point I want to make. But just one thing that fell from my Lord Justice Narasimha, which is in relation to has the critical mass of cases been brought before my lords to say there's some kind of abuse or not. Because I think there are two ways to look at this point. The first way, my lords, is which are the two countries we are akin with, at least as far as adoption of the model law is concerned, and my lords, the localized theory, England and Singapore. And both those countries have rejected the doctrine, we have not. So are you really consistent with two other countries which follow us the same meters? My respectful submission is no, that's one part of the critical mass. I don't want to give you evidence at the bar, but I can tell your lordships that there are at least 15 or 20 cases where I have been involved with. International, domestic, where these issues crop up very, very often. Now, obviously, they're not there before my lords because if a section 16 gets dismissed and jurisdiction is upheld, because awards take time to come, 34s are challenged, the issues may not be there before. But there are a number of these issues, and therefore, when your lordships is considering it, all I am requesting for is bringing about a level of certainty. Now, why would I not apply this if I was in Singapore and London? I wouldn't apply it there because if a group structure is brought, party takes a simpler route. It goes to the English Commercial Court, or it goes to the Singapore International Commercial Court, or it goes to the Singapore High Court, and says, I don't need to go to arbitration. I have a great commercial remedy. I go to court, I get the injunction I want, I get a trial disposed of within 2 years, 3 years, and that's the end of the matter. We have a commercial court structure here. And that's really,
Let's give 5 minutes to Mr. Radvani.
I'm just
grateful, my lords, for a very patient hearing. And I must just point out to my lords one very interesting aspect. It's a very personal aspect. The first time I appeared before a CB was in 2012 in the Balco case, when I appeared for the Singapore International Arbitration Center, which had filed an intervention application. And I got my 7.5 minutes on that side of the table, right towards the end. Look, this is in fact, from an arbitration perspective, the second time, I've appeared before other CVs, over that 10, 12-year period. But from an arbitration perspective, this is the second time I've actually addressed a CB on
Thank you, Mr. Thank you.
And I'm deeply grateful for a very
Thank you, Dr. Singhvi. Yes, Mr.
I just want to present a slightly different perspective. I'm not going through any case law. Your lordship has heard it all. But all institutions all over the world, and I have been part of two of them, the Singapore Arbitration Center and the Dubai Arbitration Center, the appointment of arbitrators is done by the institution. It is not a big judicial exercise. They are prima facie appointed, and then the arbitrators go into the issues, whether the group company doctrine or any other theories that are there when non-signatories can be joined, and based on the facts, they make the decision. And now here also under our section 11 has been amended. It has not come into effect, but I'm told it's very close to coming into effect. The draft rules of the institution have been published and that process is on. Ultimately, it will be the institutions doing this role that your lordships are doing today. So if your lordships leave the issues open as widely as possible for every conceivable issue where the arbitrator thinks it's appropriate to join the non-signatory, let him take the decision. There may be 7 different theories. Why should your lordship confine them? After all, if your lordship recollects, the whole group concept concept of group companies has come from where? From Dow Chemicals. It's come from an award. It's not come from a court decision. And since now we're also going toward the appointment of arbitrators by the institutions appoint only prima facie. Arbitrators will come to finding the fact one way or the other and decide this issue. And we've also done arbitrations all over the globe. The arbitrators have considered it sensibly and joined or refused to join party. This is happening consistently all over the globe. Why are we taking a restrictive view to this? Let's keep all the judgments are in place. They're well reasoned. Why do they need to be tinkered with? We have a stable body of judgments. Let the arbitrators follow them, whichever route they think is appropriate. They'll either agree, they'll join the party, or they won't join. Why do we do a narrowing exercise? Let the exercise be as broad as possible. And if an arbitrator goes too much out of line, the courts are there to correct him in a 34 application. So lordships will keep the judgments exactly as they are. The points raised in Justice Ramana's judgment were already answered by Justice Suryakant's judgment. There are several different tests. Why does your lordship want to narrow them? Let the arbitrator apply it depending on the facts of each case. And sooner or later, this is going to be an institutional exercise, not a court exercise. So let's leave it as wide as possible. Let's give the arbitrators ample room to take decisions. And if they go so wrong, the courts will correct them. Now, that was just a perspective I wanted to give your lordships. I'm obliged.
Thank you, Mr. Bani. Thank you very much. So we'll
I just had a small request to make.
conclude judgment reserved. Yes.
I just had a small request to make. Milad. We had also intervened IAA 58750 of 2023. May I have your lordship's leave? We'll put in written submissions. I want to prune it down in view of what has transpired.
Not more than 2 pages.
Absolutely, Milad. We'll try and keep it short. Grateful, Milad.
Thank you. Thank you.